Hi everyone, it's Jim Filippi coming to you from the Filippi Law Firm. Today I want to talk to you about what happens if you have a loved one that has passed and named you as a beneficiary, but also maybe there was a little bit of debt there as well. So unfortunately you've had a death of someone that's very close to you, and you were special to them because they've named you as a beneficiary in their estate plan. And there's always a concern with what happens to their debts. Am I going to be liable for them? And the answer is typically no. There are certain situations, as far as if that loved one was a spouse of yours, there is a requirement in the law to pay for your spouse's debts. However, if it's, say, your father or mother or brother and sister or someone other than your spouse, you're not going to be liable in most situations for their debt. And I say most situations because you could have co-signed or something along those lines for that debt, which would make you liable for it. But for all intents and purposes, the probate process or the trust administration process, depending on the estate and what documents that they had, deals primarily with paying those final expenses, paying any debts, and then dispersing whatever's left over. So usually, and this is all of our hope, right? We end up with, dying with more assets than we'd have debt for. What'll happen to that process, whether it's the trust or the probate process, is you're going to give notification to creditors, and they're going to make their claims, and those claims will ultimately be paid and satisfied, and everything that's left over gets dispersed to whatever beneficiaries that were named in your estate planning documents, or if it was no documents, then whatever's in the probate code. So say if there's a situation where your loved one died with more debt than they had assets for, what'll happen is basically there'll be an apportionment across all the creditors, and they'll get a piece of the estate that'll help satisfy a portion of those debts, but not all of them. And that's it, that they don't get anything else unless there's one of those exceptions I talked about earlier. So it's not like you're going to inherit that debt from your loved one. If you just think about this conceptually, what makes sense is that you're not going to be liable for someone else's debts because you didn't agree to that. I can't give you my debt unless you say I'll take your debt from you. And the same thing sort of happens when it comes to that probate or trust administration process. But again, every situation is a little bit different, and I'd hate for you to make an evaluation on whether or not you should pay a debt based solely on this video. So it's imperative that you speak with an attorney to ensure that not only are your rights protected, but you are not having to pay any debts that aren't valid against you personally. So I hope that helped, and I look forward to seeing our next video. Have a great day.